Okay, we're going to go ahead and get started. I need to finish this session by noon today because I have to teach another 4 hours starting at 1 o'clock the broker CE class for NVAR. For those joining us for the first time, we are on Wednesdays. We are literally going through our sales contract sentence by sentence. And any questions you might have, feel free to ask. I'm literally going to read it with you and give you my explanation of it. If you disagree, that's fine. But before you do opposite, discuss it with us. Okay. So look, we've made it through paragraph 10. We're going to pick up with paragraph 11. I'm in your sales contract package that was sent to you, or not sent to you, added to this emails that you've been receiving. One request that we are going to be making, I will be back in the office starting next week. I'm coming back from Daytona Beach. I want to start putting together an email list of people that have been joining us, and then if I may be doing some sessions, 5-10 minute sessions on a subject, and we will just email you and let you know if I'm going to be doing it, if you want to join or to see what we record. And these are all being recorded thanks to Nestor and put on our company's site, so you can always go back and visit it. Or if you miss one, you'll be able to pick it up on the website. So paragraph 11, access to the property. Seller will provide broker, buyer, inspectors representing the buyer, and representatives of lending institutions for appraisal purposes reasonable access to the property to comply with this contract. Reasonable access. If you're asking to go in to do a home inspection at 6 a.m. in the morning, that's not going to be reasonable. Now, you also notice it says representatives of lending institutions for appraisal purposes. And I get this one quite often. Well, it's not contingent on an appraisal. Why does the appraiser have to come in? It's not contingent on an appraisal, but it didn't say an appraisal would not be done. So no lender is going to make a loan without doing an appraisal of the property. So make sure your seller understands that even though the buyer said not contingent on the appraisal, there will be an appraisal done. If it comes in low, the buyer's still going to go with it, but there will be an appraisal. So quite often I get the call, well, they want to bring an appraiser in. It's not contingent on appraisal. Well, yes, it is. As far as the lender's concerned, they're going to make sure the property meets their requirements. In addition, buyer and or buyer's representative. Representative is not capitalized. It is not defined. I've often been asked, can they bring a home inspector back with them to do their final walkthrough? My interpretation would be probably so if they're claiming that's their representative. They wouldn't be to find anything new wrong, but probably to make sure that everything was done correctly. But representative will have the right to make, and listen to these words, walk-through inspections, not a walk-through inspection. I am amazed by how many agents say, well, you did a walkthrough on the 6th day. That was it. You get one walkthrough. That's not what the contract says. We have the right to do walkthrough inspections within 7 days prior to settlement and or occupancy, unless otherwise agreed to by buyer and seller. If this seller wants to limit this to one walkthrough, one final walkthrough, then you probably should counter this language, okay? But if I'm having a home inspection contingency removal where work has to be done on the property, you heard me say how I would counter that addendum last week for my buyer, then we need to do more than one walkthrough inspection. So Keyword is inspections. All right. Any questions about paragraph 11? Great. Let's talk about utilities, major systems. Check all that apply. Water, public, private well, or community well. If you're not familiar with community wells, I dealt with one out on Wallwood Street out in Manassas. Pretty much go through the same process. You want to make sure the well water is, no coliform bacteria, so you would still do that inspection. Okay. Now, if it's private well, and we're talking private well and septic, there is a well and septic form K1360, NVAR K1360. On Monday, when I do Ask Larry, I will be covering Form K1360 after we handle Ask Larry questions. We do meet every Monday and Wednesday at 11. If nothing goes out about the upcoming session, I will be starting up at 11 on Monday. And last Monday, I think we had about 18 or 19 people, but there was no email went out. So you use the same Zoom connection, you can come right back in for Monday and Wednesday's sessions, okay? When it comes to hot water, is it oil, gas, electric, or other? It could be solar, but you need to verify which one it is, and the listing agents, you definitely need to verify. When it comes to air conditioning, is it oil, gas, electric, or heat pump? You need to ascertain to make sure it's not straight electric. Man, straight electric versus heat pump, you need to look at the utility bills, right? Check the unit, see what it says. Get the model number. You can always go online for that company and find out. Heating is the same way: oil, gas, electric, heat pump, other. And the zones. What do they mean by zones? I was involved in a transaction on a new home out in Ashburn a lot of years ago, and it was dual zone. The lower level was gas, the upper level was electric. The theory being the heat rises, you probably wouldn't need it as much on the second level, but that was a two zone. So it could be a heating could be oil. I mean, could have been, in that case, it was gas and electric, and it was dual zone, okay? Now, real important in this paragraph, if there's a septic system, septic waiver disclosure provided by seller, if applicable, per the Virginia Code, State Board of Health septic system waivers are not transferable. So if a system has failed, if a septic system has failed, the current owner, okay, the current owner can get a waiver for them to remain in the property, okay? However, that waiver is not transferable. Before the property can be occupied by a next purchaser, it would have to be corrected, okay? There is 5 disclosures in Virginia that are required by a seller. You can find those on the website for referring people with that one-page disclosure form for them to check and see what my disclosures are, which there are 14, I'm not telling you, but there are 5 affirmative. One of the affirmative is if I am living in my property under a septic system waiver, and that's generally for one of these alternative systems that failed, then I need to give that one-page disclosure as a seller, and it's going to be recorded with my deed anyway. So when they go to try to settle, you don't want people to find out at that point, well, you can't occupy the property because I had this waiver. Okay, so it talks about sewage disposal, public septic for the number of bedrooms. Contact the county to ascertain the perk approval. could be a community septic or alternative septic system. And that's where the county said, well, we still let you build out here, but there is no gravity flow septic because the ground doesn't perk. You need to check into that alternative system if they have it, and have all the information available on that alternative system. Okay. Any questions about the utilities? Okay, then let's talk about personal property and fixtures. Property includes the following personal property and fixtures. What is the difference between a personal property and a fixture? Well, a fixture is something that's permanently attached or intended to be permanently attached to a piece of property. A personal property would be your TV set, okay? The example we use, well, the TV is mounted on the wall with a bracket. Is the TV permanently mounted? No, the bracket's permanently mounted. The TV is still personal property. This personal property and fixtures paragraph can get kind of touchy when people say, well, they took this and they took that, and they're saying, well, it was personal property, and you're saying, no, it was permanently attached. So let's just go through this paragraph. It says personal property and fixtures, if existing. This paragraph didn't used to have the word exist, if existing. I fought for this for quite some time. It just said the following items, and so they listed them. And my policy was, well, if it wasn't in the property, then they needed to put it there because you said the following existing. Okay, so they've added the word if. Built-in heating and central air conditioning equipment. Now, listing agents, be careful when you list a property. Is it completely central air? But it does say that if existing. My home in Mineral, Virginia, the lower level is central air, the upper level window units. And it's going to remain that way because I don't use the upstairs that much. I don't want to be sending any cool air up there unless somebody's going to be in. So I would probably make a note in my listing, main level air conditioning. Plumbing and lighting fixtures. Boy, plumbing and lighting fixtures. What is the one lighting fixture that causes more problems in real estate than any other fixture? It's the what? The chandelier. Okay. And once you put that chandelier up, I don't care if it's a family heirloom, it is now a fixture. If it's not going to stay with the property, you're selling the property. Owner, take it down and replace it with one that goes in its place so that there's no misunderstanding. Now, I use a processing folder. I still use a processing folder, and it has everything in there. One of the things I need to remember, okay, is if something doesn't convey, check the contract to make sure it's not in there. All right. Now, I've seen, well, how do we handle it if everybody acknowledges it doesn't go? Well, this doesn't work. Replaced with one of like kind. If there was another one like this one, would we be fighting over it? Probably not, right? So if it's going to be removed as part of the contract, then have an allowance that the seller gives for the purchaser to choose the fixture to be installed by the seller and handle it that way. It will save you a lot of problems in the future. Okay. Another one that I see is mirrors that are hanging in the bathroom. People take the mirrors and they said, well, it wasn't a fixture. It was attached with brackets, and the brackets are still there. Once you attach that thing that way, other than TV or electronic appliances, it's going to be interpreted as a fixture. So take down anything that's not going to convey, replace it. Okay. Sump pump. Not too many people understand sump pump. Do you even know if there's one in a property? Why do we have a sump pump? You try to explain a sump pump to somebody from the desert in Arizona, moving here from Phoenix or something another. We have a high water table in our area, so we put this hole in our floor in our basement. We stick this pump in there, and the water comes to there, and we pump it outside for it to come back in again. So if they're not familiar with a sump pump, take the time to explain sump pump to them. Attic and exhaust fans. Once again, attic and exhaust fans. I had a home inspector say the exhaust fan the attic fan needed to be replaced because we flipped the switch and it didn't come on. Well, it's heat activated. There's a sensor up there. So be familiar with exhaust fans. Storm windows, storm doors, screens, okay, as installed. If they're missing, then they weren't installed, right? It says if existing. So if there's some missing off the windows and you want them replaced, then you need to add that to your sales contract. Window treatment hardware, okay? Window treatment hardware. That's holding up the windows, shades, and blinds, okay? There's always an argument over the curtains and drapes, okay? You could argue that's window treatment hardware. I would argue differently, right? Smoke and heat detectors. And we do have a paragraph in our contract about smoke and heat detectors. Antennas, exterior antennas. If there's an antenna up there, I'm leaving it for you. I'm not going up there to get it. Exterior trees and shrubs. Once again, a big problem. You have been given plants from your kids for Mother's Day or anniversary, husband or wife, I don't care who received them, and you plant them and you don't want to leave them behind. Once you planted them, they go with the property, okay? So please, please dig them up, put them in a pot, okay? And then they're back to being personal property and not a fructus naturalis, as we call it, okay? So dig them up, have them out. Now, they don't want to take the stuff down. They don't want to dig stuff up. So what's your solution to that problem? We walk around and we put on a tag on, does not convey. What does that mean to most buyers? That's the first thing they want to put in the contract, all right? First thing they want to put in the contract. Chandelier does not convey, and they'll write that in there, immediately. It's Murphy's Law, right? I've come to the conclusion if there's something I do not want to move, like a pool table, I'll put on there, pool table does not convey. And invariably, it ends up in the sales contract. And I'm thinking to myself, thank you. Now I don't have to move it. So careful with that, does not convey. If you do that, write a note on your folder to yourself, check the contract, and make sure that it has been excluded from the contract. Now, this is what I call the plasma TV clause. Unless otherwise agreed to in writing, all surface or wall-mounted electronic components, devices do not convey. So the electronic devices, stereos, TVs, etc., do not convey. However, all related mounts, brackets, and hardware do convey, okay? Because they are fixtures, they are permanently attached. If your buyer does not want the mounts, etc., then you need to write into the contract that the mounts and all brackets and hardware will be removed by the seller. But also go on to say, and the holes that are left must be professionally repaired by a licensed bonded contractor or whatever you guys agreed to. I've had situations where agents call and say, well, we did the walkthrough, and when they took the pictures down, there were pinholes where all the pictures were. We want them to repair that. I don't know how you can make them repair them. I would probably leave the nails in the wall now with this new writing here, but were they already there when you wrote the contract? Okay, if they were, they're going to be there when they move out, and they're going to be there when your people move in. Tell them to be prepared for that. They may have to do some repairs to the walls and painting, unless you write in the contract that all that stuff is done by the seller. And in a multi-contract presentation, how well is that one going to fly, right? So be aware what it says here as far as those wall-mounted TVs, etc. Okay, if more than one of an item conveys, the number is noted. So the next page here, page 6, the items marked yes below are currently installed or offered. You've heard me say many times, do not leave anything blank. Okay, it's either yes or no. So if there's no alarm system, check no. If there's a built-in microwave, and there's only one built-in microwave, you would check yes, but you do not have to put one. You can if you would like. Ceiling fans. This is one that usually causes problems because you don't pay attention when you walk through the house. But you put yes, and there's 3 ceiling fans. You put 3, okay? But there were 5. Can the owner take the other 2? Well, technically no, but double check the ceiling fans. Central vacs, I don't know how many people have those, but clothes dryer, clothes washer, okay? Cooktop. Now, you know they have that new form out where you as an agent, listing agent, can post it on your listing in Bright, and it's helps the agents know all the answers to the questions that you need answered, and I would recommend that you use that form with the seller. It doesn't become part of the contract, but it takes these things item by item, and that would be one of the things you put in the download so we know how to write a contract to help you out. Okay. Cooktop. That's where the stove's built right into the counter. Dishwasher, disposal, electronic air filter, fireplace screen and door. You know how this works. Freezer, furnace humidifier. Those things always break for some reason, but you have to check your furnace for that one. Now, garage opener with remote. Remember, the garage opener is the thing in the ceiling that when you push the remote, it opens the door and closes the door. So there's usually one if there's one garage door. There might be 2 if there's one for each garage door. The remotes, remember to include those. Those are usually in a car being shipped across the country somewhere in the glove box, but make sure you have the remotes. The gas log, hot tub equipment and cover. Boy, if your buyer really doesn't want the hot tub and they're not going to use it, those things are a real pain to get rid of, especially if they have to break it up to remove it. So you might want to say under other that they have to actually take it with them. Intercom, playground equipment, you can read those. Refrigerator with ice maker, double check those. That quite often causes a problem. I've had several instances where the refrigerator had an ice maker, but the owner never hooked it up because they didn't want to have the responsibility of maybe it breaking and water running all over the house. So make sure the ice maker actually works. We had a situation when I was representing the buyer, and it said it came with ice maker, and they knew they hadn't hooked it up. And when we had our home inspection, the seller had gone down to the store and bought ice cubes and put in the ice maker, and ice maker doesn't make little ice cubes with round holes in the middle, so we sort of felt like they were trying to misrepresent the property there. It made us look even harder. The satellite dish, is it owned or rented? storage shed, stove or range, that's a separate stove or range, trash compactor, um, wall oven, water treatment system, window AC unit. Now, window treatments, okay, window treatments are your curtains and drapes, okay? I always add to this window treatments and hardware, uh, just to make sure. We had a situation years ago where the buyer and seller got together too many times, and it just said curtains and drapes convey. And we went back, and the curtains and drapes were laying on the floor, but all the hardware was removed, and we couldn't do anything to them. It just said curtains and drapes convey. So I put now window treatments and hardware. Under other, for things that are going to be transferred, lawnmower, tools, etc. I prefer that you do a separate bill of sale for those items, because technically, when it's in this contract, the lender could back the value of those items out, because they're making a loan based on the property and what's in this contract. So I generally would write a bill of sale for the other, and the bill of sale would probably say for X dollars upon satisfactory settlement of the property. Don't just write a bill of sale and say, you get everything in my property for, $3 and then not settle and just want to take everything with you. So be careful if you use it, how you do it. Check with the lender and see if this stuff is included. If that means that it has to stay in the property in the future. Now, fuel tanks, leased or owned. When my father passed away, he had these fuel tanks because he had dual zone heat, and he had a different big fuel tank for each one, and they were leased. Okay. So the new buyer, if they did not want to continue to lease with that company, then all the heating oil in there was going to be taken back by the company that had the lease, and that could become a problem. So the number of leased, or if conveyed, we had another situation where with an agent in our company where the builder or the rehab put a new tank in the ground, and he said, I own the tank. Okay. And come to find out he didn't, that it was leased, and the seller was threatening to sue everybody, even though they said, they worked out with an agreement with the company for them to buy the tank and all, claiming misrepresentation. It did get resolved, but, with threats of lawyers and everything else. So please make sure the fuel tanks, if they're leased or if they're owned. Unless otherwise agreed to in writing, any heating or cooking fuels remaining in the supply tanks at settlement will become the property of buyer. Well, if it's a leased tank, the tank's going to be removed. There's not going to be anything, right? Now, if you're the seller and you have an oil tank and it holds 250 gallons of oil, and you have a settlement coming up and you're getting kind of low on the fuel oil, are you going to go and pay, it's about $2.50 a gallon right now is what it costs me to put in my tank to fill it up. Am I going to fill that tank up for you, or am I going to just get enough delivered to make it last? So here's where I talk to my buyer, and I suggest to the buyer that we write a clause that the seller to have the tank filled the day before settlement, bring a paid receipt, and we will reimburse them for the cost of all the fuel in the tank. Okay. So if it's a 250 gallon fuel tank and there's 250 gallons in there, we know how much it costs. We'll write a check, because there's nothing worse than buying a house in like February and the seller limited the amount of oil in the tank because they're paying for it, and your buyer moves in on a weekend and it's freezing and there's no heat. So I just go ahead and be proactive with that one. Leased items. Any leased items, systems or service contracts included but not limited to fuel tanks, water treatment systems, lawn contracts, security system monitoring, and satellite contracts do not convey absent an express written agreement by buyer and seller. And you are going to list the leased items within the property. Okay. And this makes sense. Tell them who the company is if they want to continue on with it. One of the problems we might run into is part of the lease is you are leasing the equipment to purchase it, and there's still time remaining. So get that all worked out in advance. Settlement table is not a place to do it because your settlement agent isn't going to sit there and negotiate for you. Any questions about that paragraph? Because we do end up with a lot of situations with paragraph 13.
Larry?
Yes.
Question. What
Okay.
about the solar? I have one client who is asking me to sell his property, but not very soon. But he was telling me something about the solar that he's still paying that off. So what would I do if I have that listing then?
The solar is interesting because a lot of times people will put the solar up through some program that they received where they get paid to actually have the solar on their house. That's not the situation. They're still paying on the solar.
Yes, I think they're being charged monthly for the solar, for the installation of that solar. So how could I present it on the sales or in my listing?
Well, unless the new owner is willing to, and they will transfer that, and the solar company might not transfer, let the new people pay it because they went on the credit of your person. They may have to pay that off as part of the sales price.
Really?
So, yeah, so you would really need to be checking with that solar company that installed it to see if they would allow the new party to step in, because they based putting that on there on your seller's credit. Okay, I'm sure they didn't just put it up there. Ones that we run into a problem are the ones that are under a program that we put up, and the people are being paid so much money per month for the solar being on their property. We had one of those over in Maryland, a case like that. Okay, so the solar, if there's any money owed, then they're probably going to be required to pay it off unless that company will let them step in. But that's a good question because solar is becoming more prevalent, right? So you need to double check and see if there's any money owed when you list a property for the solar. And it's not like we used to be look up there and they had this big massive thing on the roof. Now with the new roof tiles and all that are solar, it almost looks like just a roof. So good question. But I would double check with the company before I put it on the market to see if they would allow it to the new owner to take over the payments, and make sure the new owner knows there would be payments.
All right, gotcha.
Okay.
Thank you.
What about the solar units that we put up where, the law says if I generate more electricity than I need, the power company in Virginia has to buy a certain percentage back. Man, there's a lot of stuff to think about. I'm thinking about putting a windmill in my home down in Mineral to generate electricity. And if I generate too much, then they have to buy some back. There's a lot that goes into it. Yeah, good question. Thank you. You always have good ones. You get interesting clients.
Thank you.
Anybody else?
Larry, this is one more. I'm sorry, but this is another listing, but this is not regarding those conveyances. About the mold, okay? What would I do if I have a house that will be listed and then the property claimed from the insurance company because there was a leak? Water leak, and then they found out that within the walls there were molds already. Am I supposed to be disclosing it here in Virginia, but it has been taken care of and it was paid by the insurance? How would I do that?
If the mold had been professionally remediated and there is been a report showing that they tested for mold and it showed negative after the repairs, in my opinion, there's nothing to be disclosed.
Okay, but what if it was like just fixed and it was the insurance who called? When you say there should be a certification, is it coming from the county or is it coming
No, it
from?
should come from the company that fixed it. They should have done a follow-up, mold and reading to make sure there's no mold in the air after they did it. So
Okay.
it should be part of that report that where the licensed bonded contractor took care of it.
Okay.
And once again, for the buyer agents, that's why I always recommend that the buyer require a clue report, a comprehensive loss underwriter exchange report for the seller to provide it, because it will go back 5 years on the insurance to see if any claims were made. So if I was a buyer and the seller supplied me the clue report that showed this had been done, then the seller needs to have all their reports in line to show that it had been corrected and tested and, it's been remediated. Okay.
Larry, can I get a report also from Geico? I mean, what has been reported
No,
to
the
them?
only people that can order the report would be the seller, because the seller is entitled to one free clue report per year on their property, and an insurance company. But other members of the public technically can't get the report.
Where do I
Okay.
get that? Where would I tell my client to get that clue report?
When they apply for their insurance, or they could write in their contract that it's contingent upon the seller providing a clue report.
Okay, so I can tell her to get a clue report from their insurance.
And they could always go to FIDO, Fairfax Inspection Database Operations, put in, if it's in Fairfax or wherever county you are, put it in and see if there were any permits pulled for work. Okay. I'm not sure that would show up in FIDO, but the two things that I would always check as a buyer is clue report and FIDO.
Okay, yeah, but FIDO probably it's not there because
Yeah.
there was no, it's probably the clue report from the insurance. Okay.
Yeah.
All right.
Okay.
Thanks.
Any other questions? Okay, let's take a look at paragraph 14, FERPA, and then we're going to call it a day for this session. IRS FERPA, withholding taxes for foreign seller. What does this paragraph mean? Pretty simply, if the person does not have a green card or they're not a U.S. citizen and they sell a property, then the IRS, the laws in the USA require that 15% of the sales price for a property over $1 million must be escrowed, and the buyer is responsible for seeing that this is escrowed. Okay, so if you're a first-time buyer and you're buying a property over 300,000 but not $1 million, okay, then it might only be 10% if you're going to occupy. That's still a lot of money. So let's look at the paragraph, and then I'm going to refer you to the IRS for FERPA rules. Okay. Seller is or is not a foreign person as defined by the Foreign Investment Real Property Tax Act. We can't guess at this. You can't look at the name Anderson and figure that they're not a foreigner. I mean, I could be, from Scandinavian country, right? So you can't go by the name. You've heard me say many times, call the other side, find out what goes in paragraph 6A and what's the answer to paragraph 14. Now, information regarding the listing form that you can use, that 3-page form that you can do with the owner and put in your site. One of the questions is about FERPA, right? When you list a property, one of the questions is FERPA, okay? As defined by the Foreign Investment Property Tax Act, if seller is a foreign person, buyer may be required to withhold and pay to the Internal Revenue Service buyer, okay, up to 15% of the sales price on behalf of the seller, and file an IRS form, which includes both seller and buyer tax ID numbers. The parties agree to cooperate with each other and settlement agent to effectuate the legal requirements. If seller's proceeds are not sufficient to cover the withholding obligations, and what's that withholding obligation? 15% of the sales price, not 15% of the profit, right? Seller may be required to pay at settlement such additional certified funds necessary for the purpose of making such withholding payments. And if this is somebody that's in another country and there's only $50,000 equity in the sale, but there's a requirement for $150,000 be withheld, are they going to bring $100,000 in here and put in escrow somewhere? Probably not. So you need to be on top of this one, and it is the buyer's responsibility. So I did some Googling for FERPTA rules. Okay. I found a nice article by Fidelity National Title under Understanding FERPTA. So let me share it with you. If someone's not a U.S. citizen or a U.S. resident, the money's going to have to be withheld. So it says sales price $300,000 or less. Does the buyer plan to use the property as a residence? If so, there's zero withholding. No, then there's 15% withholding. So under $300,000, if the buyer will sign a statement at the table that they will stay in the property for at least 24 months following, not rent it, okay, stay in there for 24 months and they're willing to take the responsibility if they don't, then the tax is still withheld, okay? 300,000 to $1 million. Does the buyer plan to use the property as a residence? If yes, and once again, they're signing something that they're going to stay there for at least 24 months, then it's only 10% withheld. If not, it's still 15% withheld. If the sales price is over $1 million, it's 15% withholding straight across the board. Okay, your buyer needs to be aware of that. Not trying to scare them off. Okay, but FERPTA frequently asked questions. Okay, and IRS has their frequently asked questions. So here's the first one. Who's responsible for FERPTA? Now this is from IRS. Okay, places a responsibility for withholding potential income due for the purchase price on the buyer, because the buyer is going to be the what? The security for the money. And it says, if the payment is not made by the buyer, the IRS can seize real property or other assets of the buyer. Other assets of the buyer. You know, am I willing to take on that responsibility just to get a property? Am I waiving everything because I'm in a bidding war? Think about the consequences, right? Can't the buyer assign the responsibility for withholding to the settlement or escrow agent? And I hear this all the time. Well, isn't it the title company's problem? No, IRS rules has no provision for you to assign responsibility to anyone else. The escrow agent can't provide legal or tax advice, nor can the agent. Okay, and what happens if one party that owns the property is a U.S. citizen and the other one isn't? Well, then they're going to require the tax to be withheld in accordance to the ownership interest. So be aware of FERPTA's there. It's why it's here. Google IRS FERPTA rules, be more familiar with them. We're not to be the person that's the expert on it, but you should be aware when the situation could arise. You list the property, make sure that seller, if they're bound by this, that they go ahead and contact the IRS right away to find out their liabilities, okay? And there are certain forms that need to be filed up front. What if they have a tax ID number? Is that good enough? No. You know, tax ID number is how they file taxes. It doesn't give them an exemption for FERPTA. All right. So we need to be really careful with that. And part of the reason being, um, if I sell a property, okay, I'm single. If I sell a property and I've been in there at least 2 of the previous 5 years, right? 2 of the previous 5 years. Doesn't have to be 2 years consecutively, any time for that period. And I sell my home. How much of the profit is tax free? 250,000.
250 per person.
250 is 250 for a single person, is 500 for married, right?
Yes.
So a foreign investor doesn't have that exemption. So how often do you see people selling houses where they don't have the exemption for 250 or 500 cover most of the profit? Well, I do have a situation like that with a purchaser that I had a purchaser I helped deal with over in Dunloring. God, man, it was 37 years ago, still in the house. And they were talking about, selling, but she's single now from the divorce and she got the property equity and whatever. And they wanted to sell that house, pay off debt, the new person with her, and build buy a new house. And I had to break the sad news to them that, yes, they've offered you 1.1 million for your house, and it's in bad shape. It needed a lot of work, but the problem is you only paid 39,000 and 250, and so 289 is tax exempt. The rest is going to be taxed. So after you pay your debt off, where are you going to move to? So they ended up having to stay there and fix the house up. There's still a tax situation there. So when you're dealing with people and you're meeting with them, and they've been in that home for a long time, okay? Will there be any tax consequence? Well, we need to get them in touch with tax people. We're not experts, but we should at least know that there could be a tax consequence.
Larry,
Yes.
can they do a 1031 with this? The owner,
You can't do a 1031 exchange on your personal residence.
I see. Thank you.
Only on an investment property. So that was the other option that I offered them. You could turn this into a rental property for 2 years and then rent somewhere, and in 2 years do a 1031 exchange. That delays it, but it doesn't end it. Unless you pass away, then your family would be okay. So, but 1031 exchange cannot be for a personal residence.
Larry,
Yes.
on this PERFTA, if there are like 2 or 3 owners in the property, just like what you said, and like one of them is a foreign citizen, so how am I going to present it on paragraph 14 where you only have like 2 options, like seller is or seller is not, but yeah, one of them is not. So how would I do that?
I would choose is not, and say contact listing agent for information,
Oh,
because
okay.
if there's 3 owners, what are their ownership percentages? So if there was some kind of an agreement showed 20, 40, 40, and the person had 20, it's only going to be 20%. But generally, if there's 3 owners, then it's 3 ways. 33% of it's still going to be subject to FERPTA. And I've had people say, well, we'll just transfer it over to the other party. No, that's fraud against the federal government. You don't want to go to jail.
Mhm.
Right?
Yeah, but this is just for the purpose of presenting or making an offer. So
Yeah.
I do not know if I will have to. For example, I have to give them like information before they write a contract or offer to my listing. So that's my question. Which box are you going to check? Like it's not,
I would check. It is not seller is a foreign person as defined. Okay, because it's still going to be, the paperwork still got to be effectuated. The purchaser is still going to have to fill out the IRS paperwork. All that type is still going to have to be done, and it's the buyer's responsibility, right? Buyer's responsibility. So I would make sure that they it was disclosed. Okay.
Mr. Larry, my question, please, if you don't mind.
Okay.
This IRS withhold tax for foreign seller, isn't it clause in the title company? Did they verify that the seller is a U.S. citizen or green card holder before
Well,
transactions?
it is, but that's already at the settlement table. So what if there's not enough money to come into the country to cover the difference? Well, the buyer is technically going to be responsible, or you're not going to have a transaction. But IRS rules say that you can't transfer that responsibility to the title company.
Okay.
It's still going to fall back on the buyer.
All right, good to know. Thank you, sir.
Okay.
Okay.
Larry, I have one question on the same topic. That
Okay.
when we are we are representing a buyer and presenting an offer, at that time we should presume that seller is a foreign national, so we should cross the foreign national, and then the seller's listing agent will correct it if it is not.
No.
Right.
Don't guess. Don't guess. Call and ask.
Okay.
Okay.
Then we have to trust whatever they say. The listing
Well,
agent says.
here's the good part, or the bad part. I wish that they would make this a mandatory field in Bright, but they have not.
Okay.
Okay. So if the seller misrepresented in the contract, okay, so it goes back to this third percent interest. If the seller misrepresented in the contract, okay, then IRS is probably not going to hold the buyer responsible.
Okay,
But
that's good.
but we can't guarantee that. They actually need to talk to what? I would get them in touch with an attorney and an accountant to help them ascertain. So there's a form that they need to file, okay? And if you're listing a property and they file the form up front with IRS, they may very well tell them what that, so it's form 8288B as in Baker, okay? So the person that's a foreign investor needs to file that IRS form, and if it's done early enough, they will tell how much is due. We had a case where it was $80,000 withheld at the sale, and we started this early on, and the actual cash money due to IRS was less than $4,000. So, but the $80,000 was being held. It will be held for 60 days, normally by the title company. Okay, to see if after filing that form 8288B or whatever it was, how much the actual liability was, and they will give the money back, the difference back to the buyer. But if this isn't done properly, and that's not going to be the title company's responsibility to ascertain how much it is, it's the buyer and seller's duties to file the proper paperwork. Then after 60 days, that money's probably going to end up at IRS. Could the buyer get it back, the foreign person get it back? Yeah, when they file their income tax the next year with their tax ID number, okay, they will probably get back the difference. But, you know, the key to it is the money going to be enough money there at settlement to be able to do the settlement? And if it's not collected, is the buyer willing to pledge all their assets if IRS determines they didn't do what they were supposed to and they want their money? So, it's something that needs to be discussed. You're the listing agent?
No, okay. I was asking for the buyer's perspective.
Yeah, but I'm saying if you're the listing agent, there's a question in your listing agreement. It says the same thing as this. And on that information to purchase form that you can put into Bright, you can put on, the answer would be there. We have the right to rely on it. But for me to automatically check, okay, that, the person is not a foreign person, and then they don't correct it, I don't know how that would be ruled upon.
Okay.
Could the
Okay, thank
listing agent catch it? Because quite frankly, when a contract is presented, do the agents go through the whole contract with everybody and double check? There's always something that is not checked right or whatever. I'm not gonna leave that one open for saying, well, we checked it, they didn't change it. I'm gonna be proactive. I'm gonna make sure. Okay.
Okay,
Okay, but you can't leave it blank, right?
yes.
So we have to make a choice. I understand.
Hi, Larry. I have a question.
Okay.
I understand what you just covered with FERPTA. What I don't understand is why is it the buyer's responsibility? I know it is what it is, but I just don't quite get why it would be the buyer's responsibility.
The IRS's position is the liability runs with the property.
Liability it runs with the property. Okay.
And so if it's a foreign investor, can IRS go into another country and collect taxes?
Ah, no, I see. Very good. Thank you. I just needed I was looking for trying to connect the dots. I said, this just doesn't make sense. We're going around and around, but it is what it is. And I understand that now. Thank you.
Okay. Good. Any other questions? Great. I need to take a break because I need to teach 4 hours here this afternoon, Broker CE, and I need to get set up for it. So thank you for joining me today. It's great to see so many people on these sessions. And I will be on again Monday at 11 a.m. and I'll actually be doing it from the Tyson's office Monday. And I want to go over the well and septic inspection form that day, plus any other questions you have for Ask Larry. Okay?
Okay,
So-
thank you, Larry.
Thank you, Larry.
Thank you for joining, and I will see you guys again, hopefully on Monday morning.
Larry,
Thank you, Larry.
Thank you. Thank you.
Okay.
Thank you. Bye-bye.
Bye. Thank you guys for joining.
Larry.